Let me give you a rule of thumb that I want you to follow, and the reason I'm telling you this before we even teach you anything about living trust is because I'm going to harp on it again and again and again. Here's a rule of thumb. Rule of thumb. You know what a rule of thumb is, right? That means maybe not in every single situation, but pretty much every situation. Rule of thumb. Make sure that whatever you own, say it, whatever you own at any given point in time in your life, it better find its way back to your living trust. Now, that's a pretty important statement. Whatever you owned at any given point in time better find its way back to the living trust. Because if you don't, it will be probated. We're going to show you how that works, why that works. I'm going to tell you that right up front. I'm going to tell you again and again so that you'll know that whatever you own at any particular point in time better find its way back to a living trust. Now, if you make sure that it finds its way back to the living trust while you're alive, are you collecting, is your living trust a collection entity? So when does it become a distribution entity? When you die. Bingo. You see, what happens is because you took the time and the effort to make sure that you collected everything that you own at any particular time back to the living trust, now, when you die, that trust has the power to distribute all of those assets in a manner that you have already previously thought through and left instructions for. I want my assets to go to my children, share and share alike. I want half of it go to the charity. I want half of it go here. It's all laid out. Now it becomes the distribution entity. So your living trust really becomes both the collection entity while you're alive, and it becomes the distribution entity when you pass on. Now that's all fine and well, but I don't even want to talk about living trust right now after all of that, right? And the reason is because I want to give you an introduction about trust, period. You know, most people are so intimidated by this thing called trust. Think about all the different kinds of trust you've ever heard of. Living trust, irrevocable trust, revocable trust, spendthrift trust, bypass trust, family trusts, marital trusts. Wow. Is that enough to intimidate you? Can I tell you a secret? It's all smoke and mirrors. Did you know that a trust is a trust is a trust? And every single trust that's ever been created is really just a trust. And it might become a lot more clear if we go through and give you a little bit of background. The truth of when it comes to the history of trust, there's an interesting story that goes on clear back in good old Mama England long before this country became a grand old US of A. And the way it worked was that it was, at that time, if you lived in England and you had property, when you died, you were taxed on that property if it could be proven or shown that you not only owned the property, but you also enjoyed the property. Now, I don't even want to go how ridiculous this might sound to you. Governments didn't start yesterday. They're just as ridiculous then as they are today, right? But the point was, as long as you enjoyed the property and you owned the property, when you died, you had to pay taxes to the king. So some really bright people, little bright legal people got together and decided to put together a little tool that would kind of separate those things out a little bit. And if it could be proven that the person who owns it didn't really enjoy it, and the person who enjoyed it didn't really own it, there's no such thing as you didn't have to pay taxes on it. And they did that through a little tool called trust. That's exactly right. So a trust is a trust is a trust, and it became set up that really, the best way to look at this is that a trust is nothing more than a set of babysitting instructions. I can't get more simple than that. Why would we even think about calling it a set of babysitting instructions? Well, think about it. If you are leaving to go on a date, and that's a good thing to do once in a while if you're married, by the way, I found out, right? And you got children, and you got a babysitter coming, what's the purpose of the babysitting instructions? This is really hard, right? It's to give the babysitting instructions as to what they're supposed to do while you're gone. Now, there's some interesting things to learn here. Who writes the babysitting instructions? Mom and Dad. Who's the babysitting instructions for? The babysitter. You know, when you're writing up a trust, we call that a trustee. And who's the babysitting instructions going to benefit? The baby. See, the beneficiary of the babysitting instructions is the baby. And so, really, that's all a trust is. A trust is literally nothing more than a set of babysitting instructions. And then the next thing is, listen to all those names we came up with. Boy, that's enough to intimidate all kinds of people. Do you know there's not even any official names for trusts? They're nicknames. And the reason we come, and where we come up with a nickname for a trust is for the purpose as to why we wrote the babysitting instructions. Let me give you an example. Why don't we put together a trust? And the purpose why we're going to put it together is so that you can put some money into it on a regular basis for a whole lot of years. And then at some point down the road, you're going to stop putting money into it. And then you've got a little arrangement with the government that all during those years while you're doing that, they're going to let that money grow without having to pay any taxes in it. But down the road a ways, you finally decide that you want to start taking the money out and living on it. That's a trust. Okay, what do you think we should name that trust? This is going to surprise you. Who said it? It's called a pension plan. Bet you didn't know that. It's just a trust. And because of the fact that it's going to be a thing that you're going to put money into, and then you're going to turn right around and take money out later, wow, what are we going to call that? Well, let's call it a pension. Good name. Let's do that. There's no big official dictum or rules. When you hear about all these different kind of trusts, they're all just a trust. But they have a set of babysitting instructions that were established for a specific purpose, and so we just gave them a different nickname. So don't get intimidated by all of that. All right, there are three parties that are involved in every single trust. Remember, a trust is just a trust. The first party is the party who is going to write up the babysitting instructions. Now let's say we're talking about a living trust here. In the case of a living trust, who's going to write up the babysitting instructions? You are. One time I had a lady say, well, I don't know how to do it. Well, I'm kind of joking around with you a little bit. Your attorney's going to help you do it. But officially, who signs the document as being the ones that roll up the babysitting instructions? You. So you get to write the babysitting instructions, and even if your attorney helps you, you get the credit. Okay. So in the case of a babysitting instruction, you get to write it. And that is called the trustor. The trustor. But there's a couple, two or three other terms that we sometimes find are pretty much synonymous with the trustor, and one of them is called a grantor. And the reason I put that in the middle is that is why sometimes you keep hearing about a trust called a grantor trust. You're putting the trust together, and that's what a grantor trust might be. So when you put together a living trust, where you see grantor, trustor, or settler. If you go to law school, you'll find there's a little bit of legal difference between these terms, but as it relates to your living trust, they're pretty much the same that we're going to be talking about here. Is everybody okay with that? Okay, now the next party, they're the ones that create and fund it. All right, the next party is the trustee. Now the trustee's responsibility is to control, manage, and direct the day-to-day affairs of the trust. In the case of a living trust, who's that going to be? You? Well, wait a minute, I thought you said you were the one that started the trust. You mean you get to do both? What a deal. That's exactly right. You get to do that. Now this is important. What happens when you decide, or what happens if you die, or you become incapacitated, or you become mentally unable to continue to function, or whatever? Can you have a successor trustee that can step in and take your place and have that be specified in the trust? Absolutely. Just remember, the trustee is nothing more than the parties who are involved in managing the day-to-day affairs of the trust, and you've already told me that that is you. Then you always have a beneficiary. Beneficiary is who benefits by having had the trust written up. In the case of a living trust, who's the beneficiary? You are. Wait a minute. I thought you were already number one and number two. Can you be number three as well? Isn't that interesting? In the case of a living trust, you've just fulfilled the benefit of being able to live all three. And so the beneficiary is the person who receives the benefits. Now, by the way, did you notice that the trustor is the one that the title holds title to, but the one down here who's the beneficiary is the one that holds equitable title? That means the other ones that benefit from it. You can see why in good old Mama England, when you set up one of these tools, then you didn't get taxed because you had a trust set up. Because you separated who owns it and who benefits from it. You know what? Parents do that all the time. Now, there are two types of trusts. Every single trust we've told you about has those three parties. This is not complicated. A trust is a trust is a trust. You got a trustor, a trustee, and you got a beneficiary. Done. But there are two kinds of trust. The first trust is called a revocable trust. We told you earlier that's sometimes referred to as a grantor trust. Now, why do you think we call it revocable? Boy, this is really a tough question, you know. Is this a question? No. That means that once you establish the trust, you can change it anytime you want to. You can modify it, tweak it, you can cancel it. And that's a good thing, because when you set things up in a living trust, let's say your bank accounts, your checking accounts, and so forth, do you still want to control your assets? Do you still want to control your financial affairs exactly the same way after you set up the trust as you did before? Is that right? Does that make sense? Sure you do. When you set up a bank account and you go down and put it in your trust, you're still going to be able to do that, deal with that bank and write out checks just as well as you would even before you had it. So why do you have it? If you can change or modify it and so forth, well, let me tell you why. Because it does nothing for you while you're alive. This is really important to understand. You can change or modify it or tweak it, but from the IRS's point of view, because you can do everything with that trust after you set it up as you did before, the IRS is going to let you in on a little joke. They just consider that it doesn't even exist. You don't even have to get a tax ID number for it. Let me prove this. At the end of the year, when you have a savings account at the bank, would you agree with me that the bank sends you a little piece of paper called a 1099 that tells you exactly how much interest you earned in the bank? Yes? Okay? So if you have a living trust and they're sending this bank statement to your home addressed to the trustee of your name of your trust, where do you put that statement that they just sent you, that W-9? Where do you include it? Did you know that you just put it on your regular 1040? The IRS says, do us both a favor. Just forget you even have it. You don't have to file a separate income tax return for your living trust at all. Just put it on your regular old 1040 and we'll pretend it doesn't exist. And you know why? Because the IRS basically says that since you can do everything with that trust after you set it up as you did before, the IRS says it's nothing more than a clone of you. And therefore, let's just not save anybody, let's not cause any grief or any problems, let's keep things simple. So why in the world, if a living trust does absolutely nothing for you while you were alive, why in the world did we set it up? Thank you. I mean, did you hear what he said? If a living trust does absolutely nothing for you while you're alive, why would you set it up? Because you want it to kick in when you die. Thank you. That's why we have living trusts. Living trusts kick in to make sure that the second you die, all of your estate is now in place, ready to be distributed. It doesn't have to go to the courts to be able to determine how you want your estate to be distributed. It's all included. So the purpose of a living trust, for the most part, is an estate planning tool for when you die. It was never intended to do anything for you while you're alive. Now, since I'm on that vein, I want to say something that normally I might say later, but I can say it later as well because I'm the speaker and I can decide how I want to present it, right? Since a living trust does nothing for you, either help you or hurt you while you are alive, what do you think your living trust does for you in protecting you against lawsuits? Zip, zero, nada. For the most part. There might be rare exceptions, a little bit case here and there depending on what state you're in, etc. Just to understand, it doesn't do anything for you. We have to rely upon other tools for lawsuit protection, you know, like limited partnerships. But when it comes to estate planning, we use this tool to take care of things for when you die, but it really does nothing for you while you're alive. And that's why the IRS taxes everything that is in your living trust. It taxes it to you as if you were an individual. Now, having said that, if you have a great big fat estate worth several $billion and it's all listed in your living trust so it won't go through probate, The second you die, whether you have it listed in your living trust or not, is all that money going to be subject to estate taxes. This is a hint. You know, if you didn't go like this, you missed it. What did I just say? Does a living trust help you or hurt you while you're alive? Does nothing. Does the IRS look at it to you as a clone? Does that mean that they're going to tax it to you as an individual? Okay, now does it make sense that when you die, if you have $1 billion estate, even if it's in the name of your living trust, is it still going to be subject to estate taxes? Yes, that's exactly right. So you get no estate tax purpose benefits. The only benefit you get for estate tax purposes is that, remember, we said that if a husband and wife enters into a living trust contract, whatever the size of your estate is that will be established that year by the law will be automatically doubled. But then that's because you each get your share anyway. See, that's the point. All right. So why in the world then, the reason I'm stressing that to you is because I want to introduce you next to irrevocable trust. And the first question that comes up is, why would I ever want to set up an irrevocable trust? I can't do anything with it once I start it. Man, I got handcuffs on me. I can't do anything with it. Why would I ever want one of those pieces of junk? Because of what we just said. We need to think about some sort of a strategy that would make it so that when you die, anything in that trust will not be included in your estate. And that's a major point to talk about. Irrevocable trusts, once you set up the babysitting instructions, and you can do anything you want. When you set it up, who's writing the babysitting instructions initially on a irrevocable trust? You are, right? And you can do anything you want. You can set it up any way you want to. But once it's done, and you set it up, and you signed it, you walk away from it. What does irrevocable mean? It means you no longer can change, tweak, or modify it. Now, because that you now no longer can do anything you want with that money after you've signed it, worlds without end, the IRS cannot include that in your estate. It's own of you. Did you know that when you set up an irrevocable trust, it is not you, therefore it requires its own tax ID number and files its own income tax return. And that's why it's a powerful tool if you have assets and your estate is large enough and you do not want to make sure that some of those assets get included in your estate. That's why we set it up. Now, somebody raised their hand. Can you hold just one sec? Just one sec. I want to make a point here. What did we say a few minutes ago was the number one asset that personally generates more personal estate taxes to the IRS than probably most any of the others? Life insurance. Here's this great big chunk of cash that occurs when? When you die. You know, one of the most ridiculous things I found very early in my career was when I heard about people who were told by their insurance agent that they needed to buy an insurance policy so that they could have money to pay estate tax. Okay, well that may be true, but isn't it kind of ironic that before it ever used one dime to pay estate taxes, it had to pay estate taxes on itself first? Is that crazy? So what we do is we have a very specific strategy called an irrevocable life insurance trust. So there's an example of where we nicknamed a trust for the purpose of writing up a life insurance policy, one of those big assets that normally would kill you in taxes when you die, and we want to get it out of your estate, so we set up an irrevocable trust for the purpose of being able to house that particular policy, so when you die it will no longer be included in your estate. And since we're using it for life insurance, what did we say? We're going to get real creative, you know. We're going to have to come up with a name for that, and we decided to call it what, did we say? Oh, wow, how creative is that? You know, irrevocable life, that's as creative as the IRS calling it a 1031 exchange. Or your kids number 1, 2, and 3, 4, and 5. So this is why it is. It's just an irrevocable trust. Now let me stop here and give you another example. I told you that my wife and I have 7 kids. Does it make sense that all of our children, does it make sense that perhaps one of those children cannot stand to have 5 cents in their pocket for 5 minutes without it burning a hole in their pocket? You think? Yeah, well, I had a lady come up one time and say, how about all 7? It'd be interesting to go into detail on her story. Actually, I have a case exactly like that. The case that I have is that I have a daughter that if I were to leave her $1 million, I will tell you that it would be gone in 2 weeks. But it's actually for a very good purpose. This young lady is the most loving, kind, giving person I've ever met in my life, next to my wife, that I've ever met. And the reason why it wouldn't be around is because she is so generous and so giving, she will have given it all away by the time, in about 2 weeks. She'd go through this huge list of all of her best, charitable organizations, people who need it, etc. See, so it's a very good reason. But I may be concerned about her generosity and decide to protect her against herself. So I decide then to set up an irrevocable trust. So we decide to set up this irrevocable trust, and the instructions say that we're going to hire a professional trustee that's going to manage this $1 million for her. And the babysitting instruction says that the trustee will now make a distribution to my daughter on a regular basis, whether that's quarterly, monthly, or annually, or whatever the case might be. And this trust is going to pay her out for the rest of her life. What do you think? Well, now let's see. We got to come up with a name for this. We only do nicknames, So what are we going to name this kind of a trust? How about it, Protect My Daughter Trust? Well, let's get a little more sophisticated than that. Somebody said the name, I heard it. How about Protect my Trust, My Daughter? How about a Spendthrift Trust? Is that good? That's all it is, class. It's just a Spendthrift Trust. Now, there's several things that just took place. And I want you to think about this. First of all, what if I died tomorrow? How much of that will be included in my estate? What kind of a trust is it? It's an irrevocable trust. What did we say? If you have monies in an irrevocable trust, worlds without end, the IRS cannot include it in my estate. It's now out of my estate. So that will not be included in my estate. There'll be other factors. Okay, that's fine. Let's go one step further. When the manager, the trustee, manages that money and earns a profit on that $1 million, whose income tax return will that show up on? It's not going to show up on mine. Now, it could be taxed to the trust, and that's worth one more little thing under here. You see where it says taxed under trust rules? Let me explain that. The IRS does not want the trustee to leave that money in the trust and then pay taxes on it at the trust level. The IRS has done something to encourage the trustee to pass that money out to the beneficiary, which in this case would be my daughter, and have it show up on her income tax return. If the IRS wants them to do something really bad, what could they do to provide incentive to do that? They tax the trust at such a horrendous rate, and I mean really horrendous rate, that it's so usury that no trustee in their right mind would ever file and keep the profits in the trust and then file it with the IRS and pay taxes at the trust level. What they're going to do is they're going to pay out the profits to the trustee, which is my daughter, and then because they paid out all the profits, that zeroes out the trust. There won't be any trust. But then when she files her income tax return, now she has to declare that she got that money. Does that make sense? So there's incentive for the trustee to pass that down. That's why I put down here it's taxed at the trust rules. So now you've already told me that it won't be taxed at my tax bracket, it's going to be taxed at her tax bracket. Here's another one. What if when I died tomorrow it was because I caused the accident and I killed a few other people in the accident as well, and all of their estates sue me? And the mother of all lawsuits comes against me. How much of that money inside that trust can that lawsuit touch? Nothing. You see, these can be powerful tools to solve some amazing problems for your situation. I know you can't change it after you set it up, and that might seem to be on the surface to be a negative reason for not having it, or for not wanting an irrevocable trust, but the truth of the matter, there's too many other areas of your financial lives where they are unbelievably awesome tools. They solve huge problems in your family. How about another one? I'll give you one last example and we'll move on. A few years ago, I had somebody come up to me and say, you know what, I'd like to leave my daughter a substantial sum of money that we're planning on giving to all of our kids, but my particular daughter, this daughter, is in a very bad marriage, and we're concerned because we think it's going to head for divorce. And we're worried that if we give her an awful lot of money and leave her a big deposit, that when it gets a divorce, that her husband in this bad marriage is going to end up with some of that money. Is that a valid concern? Sure is. So they were talking about what we might do. And the law firm recommended that what they do is to set up an irrevocable trust, exactly as we just talked about. And in this particular case, the trustee would then manage the money, give a distribution to her for the rest of her life, but she doesn't own the money. So now when the divorce occurs, they can't consider that as an asset in the divorce because it's not even in their name. She didn't even own it. So did we just solve a particular problem for a particular family because we understood the power of trusts? Class, listen to me. I love trusts. They are amazing friends of your family. They are amazing, wonderful, powerful entities that can solve individual problems just like winning an individual chess game. And now you understand that all trusts are either revocable or irrevocable. Now, I want to make one more interesting comment about revocable. Let's say you set up your living trust. And who did we say can change it anytime you want to? You can, right? Well, who's the successor trustee? You're the trustee. Who might be the successor trustee? One of your kids, right? Right, your children? Here's what I'm trying to point out. The split second you die, and they take over now as the trustee, do you want to give them the power to change everything that you put inside the babysitting instructions because they just might want to change it to their benefit? What do you think? Of course not. Did you know what happens the minute you die? In that split second you die, that trust went from an irrevocable trust, or a revocable trust to an irrevocable trust, just like that. So isn't that interesting? So you're going to be acquainted with this. So you see, all trusts are either revocable or irrevocable. And sometimes they can start out with one and then end up being another. And that's how that works out. All right, well now you understand that. Now we can go ahead and start talking about this. Yes, now your question.
Just going through that right now, something else happens right at that point. If you're the trustee, by the time you take care of final expenses, burial, medical, whatever, even after you've done that, then it goes through the attorney, then there's a 120-day period before you disperse that.
Well, yes. Now, again, a lot of that has to do with what state you're in. Different states have different distribution rules, et cetera, et cetera, et cetera. I might try and touch a little bit more on that. I hope I remember to do that when I get a little further into here, and I'll show you another example. Once in a while, somebody will say, well, this is the greatest thing since sliced bread. Yes, it is. Well, is there any advantage of using a will over a living trust? I mean, it sounds like, who would want to go in to have a will? A will guarantees probate, right? So who would want to use that? Well, let me try and remember and touch on that, and you're going to help me remember that, okay? Because it kind of relates to the same thing. All right. So this particular trust holds and disposes personal assets and interests. We use it because it avoids and or helps reduce estate taxes. It certainly avoids probate if funded properly. Okay, here's how it works. Before you die, excuse me, do you all know what that means? Would you think that means while you are still alive? Are we good for that? And if you think I'm being cute with you, I guess I am, but I'm trying to make a point. Did you know that it's been estimated that 99% of all the people in the United States of America who currently have a living trust will still go through probate? Because they didn't understand what I just said. While you are still alive, it will be absolutely critical for you to go down and actually list or identify on the trust what you don't want to go through probate. You must somehow connect or attach whatever it is that you own so that you will make it that when you pass on, those assets are specifically listed on your trust. Ladies and gentlemen, my friends, if you do not do this, the trust will now have no power over those assets to prevent them from going through probate. You know, there have been billions and billions of dollars in legal fees in this country that have been charged by estate planning attorneys setting up living trusts for their people without helping their clients to understand the importance that when they walk out of that office, that trust that they just paid a potload of money for is a worthless piece of paper if they don't teach their clients how to list all of those things down there on their trust. Now, this identifying or listing or connecting or attaching has a legal name for it that you're going to memorize from now on. It is called funding the trust. Ladies and gentlemen, only a funded trust works. Only a funded limited partnership works. Only a funded limited liability company works, etc. Corporation, you name it. So what I guess I'm saying here is that the reason I like starting off with living trusts here is because many of the principles that you're learning right now cross-pollinates over to the other legal tools, and they follow exactly the same way. So this funding process is critical. I cannot tell you how many times over the years we have people saying, oh yeah, my accountant or my attorney set me up a living trust, but I still have everything in my own name just like I always did. Well, guess what? You're in trouble because you're still going to go through probate. Only a funded trust works. Well, then we better discuss then how that works. Well, there are two ways that are more effective in doing this than most any of the others. And the first way is to understand the power of taking title to the name of the trust to begin with. What does this mean? Well, first of all, let me tell you something that makes obvious sense to every one of you when I bring it to your attention. Did you know that there are certain assets in this country that you are not legally permitted to own unless you actually own it in some name? You want me to give you a prime example of that? Bank accounts. Bank accounts. What happens if you went down to the bank to set up a bank account, and you know they get all excited about that these days. You know they slobber all over themselves because they're so excited you're going to set up an account with them. And they roll out the red carpet and and all the other stuff and whatever. And finally it gets around to the discussion about setting it up. And one of the bank officers or the account executive is going to say, well, just exactly whose name would you like to set up the bank account in? Now tell me where you think this conversation is going to go if all of a sudden you look at them a little surprised and you say, oh, we don't want to set it up in anybody's name, we just want a bank account. Where do you think that conversation is going to go? They're going to throw you out the door for being a lunatic. Because there are certain assets you can't own unless you own it in some name. Bank accounts, real estate, your automobiles. Go through the list. There are things you have to own in some name. Well, now's the time to break some other news to you. What are the two ways in America that most people in America hold title to those kinds of assets? Can I give you a hint? The first one is individual ownership. What do you think the second one is? Joint ownership. You ready for this? Those are the two worst forms of ownership if you are interested in lawsuit protection, income tax reduction, and estate planning. People in this country who understand estate and asset protection realize the power of utilizing these tools and then holding assets in the name of those tools and not in your own name. That's the idea behind everything we're talking about. If you own an asset and it's not in your name, but it happens to be in the name of the living trust or the limited partnership, that's the biggest deterrent that a trial attorney could ever come after you with. They want to have everything held in your own individual or joint ownership name, because those are the two worst forms of ownership. Asset protection has everything to do with how you hold title to your properties. Everything has to do with it. How you hold title to your properties and the amazing legal tools that we can use that protect us from taxes, from estate planning, tragedies, lawsuits, has everything to do with how you hold your property. And the vast majority of all of Americans simply hold everything in their own name or in their own joint ownership name, and no wonder they've got so many problems of leaving themselves open. All right, well, how do you hold title to stuff? Well, it depends. If you are married, we have three different ways that you can actually hold property. Now, the reason we always start off with married is because if you're single, you can extrapolate how this makes sense. It's easy to figure this one out. You just do it with one of those, and that's it. But it's a little bit more complicated if we talk about a married individual, so I'm not being biased against you if you're single. I'm just saying it's easy for you to figure out if you're single, but it might be a little more difficult if you're married. So here's how that works. You can actually take title to the property in an hours format, and that is considered generically that each owns it half. All right, so what happens when you set up a living trust and it's a married couple? It's really two trusts acting as one for the most part. So generally speaking, what we see happen is unless you're going to specifically put your assets on one side or the other, it is an hours format, and it is considered to be the generic format, and therefore when you do that, each equals half and half. Let me show you how you might word that. It might say something like this. G. Kent and Christine C. Mangelson, G. Kent Mangelson and Christine C. Mangelson, trustees of the Mangelson Living Trust Agreement dated October 2nd, 1981. Now listen to how I worded that. G. Kent Mangelson and Christine C. Mangelson, trustees, are both the trustees of this trust. Of the Mangelson Living Trust Agreement dated October 2nd, 1981, did it specifically mention which one of us the trust is established in? It just said what? Mangelson, right? Didn't it just say Mangelson? Didn't say one or the other. That's the generic format. So any asset that is listed that way is automatically considered to be owned equally by parties. Now, let's say that for some reason you might specifically want to have an asset held in one side. Maybe you're coming into the marriage with a previous marriage. Maybe you already had assets involved in it. Maybe you had a business partner, and I don't know, whatever the point is. For estate planning purposes, any number of reasons, it might very well be that you will want a certain asset to be labeled or to be named in one side or the other. So the top one here is his. Let's start there. Here's how it would be written. G. Kent Mangelson and Christine C. Mangelson, trustees. Who's the trustees? Both of us, right? Can we both be trustees? Sure. Okay. Of the G. Kent Mangelson Trust Agreement dated October 2nd, 1981. Now, did it specifically mention my name? What if we want to hold it in Chris's name? G. Kent Mangelson and Christine C. Mangelson, trustees of the Christine C. Mangelson Trust Agreement dated October 2nd, 1981. There you go. So this is how that's done. And in your legal documents and so forth, it will give you some suggestions on how to do that if you forget when you're filling this out, if you do it by yourself. All right, this works extremely well. But what about if you went in and you took an inventory of everything you own? I mean that. If you go in and you actually get a big old piece of paper, you better get, maybe a whole ream of paper. Because if you go through and you list anything and everything that you own, all of your financial interest, etc., and I'm not talking about paper clips, and notebooks. I'm talking about anything that's of any financial value and or of sentimental value that your children will fight over. Those are the kind of things. All right, so any of those kinds of things. You make an inventory of that. You know what you're going to discover? You are going to discover that most everything you own, you just own. You don't take title to. Only very small percentage of things do you actually take title to. So how do we take care of those things? We do it with the use of a Schedule A. Memorize it. Every single legal tool that we're going to tell you about has its own Schedule A. And all the Schedule A is nothing more than a little piece of paper where you simply write down on the paper whatever it is you want to be attached to that particular legal tool. Okay. And if you think it sounds complicated, oh, it's not. Let me give you an example. The doorbell rings. You're so excited because they're going to deliver your brand new grand piano. By the way, I really hope somebody in your house knows how to play the grand piano for what you just paid for it. Would you all agree with me that grand pianos, quote unquote, ain't cheap? Very pricey. So you've bought one, so we assume somebody's going to be able to really appreciate having it around. So you're all excited. You tell them exactly where you want them to be able to put the piano in your home, etc. And while they're putting it into the proper place, you're thinking, whoa, I don't want this to go through probate. We paid enough money for that. We certainly don't want to go through probate. So here's what you do. You run into the back room, you get your living trust, and you flip through the pages till you get to the Schedule A, and then you do a really hard thing. You write down the word piano. Steinway, model number, serial number, that's it. It's funded. It will never go through probate. You see, this is not difficult. It's just different than holding property in your individual or joint ownership and then let everything go through probate with a will or whatever. So these are the things, and it works really well. It works so well that we use it for all of our clients and our students and anyone that we talk to and teach. All those who having zero size estate up to $1 trillion, and you told me that includes everybody you know, and that's why we use this tool. It's a wonderful, wonderful tool. It's the most loving tool you'll ever set up. You know, I've seen people buy, and they don't do this on purpose, they did it in ignorance. They end up holding all their assets in individual or joint ownership name, and when they die, then this big list ends up in front of the judge, and then they sit and argue about it and fight about it. I want you to know on a serious note, because I have seen it hurt me really bad. I've seen really good families have a stake driven right through the hearts of the relationships of their children, and have their children never speak to each other again, because mom and dad didn't understand the power of a living trust. This is the most loving tool you'll ever set up. It solves huge problems like his, hers, and ours assets, or his, hers, or our children, and you can't solve those problems by holding assets in individual or joint ownership and then letting them go through and fight over it from now on. Okay, we're going to break now, except for I got one thing I want to just finish off since we're already there. The one thing I want you to understand is, even though that you may end up not having to have probate, or maybe your estate is even small enough or large enough that you've figured out how to not pay any estate taxes, I need to warn you something that I alluded to a little earlier, and it's a good thing to close on. As amazing as living trusts are, please understand that living trusts will not protect you from 3 L's. What are the 3 L's? Lawsuits, levies, and liens. It's exactly right. They were never designed to be lawsuit protection tools. They were designed to be an estate planning tool when you die. Living trusts, for the most part, do nothing for you, either help you or hurt you while you are alive. That's the idea.